Good afternoon. My name is Tamika Miller. I'm the Executive Vice President of the Greater New Haven Chamber of Commerce. And we're having a really good, informative lunch and learn today about Connecticut and federal workplace laws. And you're going to learn about recent developments, what they mean for your business. So we're going to give a few more minutes for people to join, and then we will get started. And we're going to hear from three different presenters today. We'll just give a few minutes. I see the numbers going up in terms of participants. So we'll just give a few more minutes and then we will start. Again, if you're just joining us, my name is Tamika Miller. I'm the Executive Vice President of the Greater New Haven Chamber of Commerce. And we are going to be talking about Connecticut, state and federal workplace laws and all the implications for your business, updates, new information for you to know. And we're going to give a few more minutes for people to join. Okay, let's get started. Thank you for waiting. Hopefully you have something yummy to eat and you're ready to sit back and while you're eating your lunch, you can hear three different presentations or three different speakers, and they're all going to tell you a little bit about the topic here, and it's all about Connecticut state and federal workplace laws, updates, implications for your business, what it means. So please, we encourage you to use the chat. We are recording this. We will have this on our YouTube channel afterwards. So if you have questions about the presentation, you can definitely take your notes during the presentation today live, but we will be placing this on our YouTube channel. And we encourage you to visit that often because we have other recordings and footage that we think would be helpful for you. We have an hour and we will probably finish like around 12:50. So if there are questions that you have that you want to ask live, you can type those in the chat, or you can type in the chat as we are going. Again, Tamika Miller, Executive Vice President of the Chamber. I'll also put my information in the chat if you have any questions about other topics that you want to talk about. And now it gives me great pleasure to introduce Jennifer Falzone. She is our very worthy and capable counsel, volunteer, and representative for our HR council, our Human Resource Council. And so Jennifer, please, if you'll introduce yourself and then our next speaker. Thank you.
Sure, thank you. My name is Jennifer Falzone. I'm the Senior Vice President of Human Resources at Marrakech. Marrakech is a nonprofit human service agency. We provide person-centered services to individuals with all abilities throughout Connecticut. I'm also the co-chair of the HR Council through the Chamber. So our HR Council is a great group of HR folks, and we meet monthly. We talk about some HR issues, and we try a few times a year to bring some important information back to all of you. So if any of you are interested in joining the HR Council or have any questions, you can contact me or Glenn Archer. I'll put both of our contact information in the chat. So welcome everybody. First, I'd like to introduce Lisa Kidder. Lisa is the Strategic Communication Manager for My CT Savings. She's responsible for business outreach and marketing communication efforts. She's worked in communications for her entire career in the private sector as a business owner and now in the public sector. So she's going to give us some information about the My CT Savings program.
Thank you, Jennifer. Good morning or good afternoon, everyone. I want to thank the Chamber for allowing me a couple of minutes to give you some information on the MyCT Savings Program, and thanks for the HR Council as well. I want to make sure that I was told there were a couple of questions specifically you wanted me to address, so I'm going to make sure that I cover both of those topics. The first one is, why was the MyCT Savings Program established? And we'll start by telling you that it was established to address the retirement gap in Connecticut. And let me give you a few stats about that. The Pew Charitable Trust studies show that when employees have the opportunity to contribute to a retirement plan through their employer, they are 15 times more likely to save for their own retirement. However, in Connecticut, only about 44% of businesses offer a retirement plan to their employees. So, and that's not because they don't want to, it's primarily because they either can't afford the cost of a plan, they don't have the ability to deal with the administrative burden or the risk to the business. Another study from the National Institute of Retirement Security showed that 55% of people are concerned they won't be financially secure. And Bloomberg studies show that 1 in 4 people have not saved for retirement at all, which leads me to my most sobering statistic. And that is from, again, the Pew studies, that the lack of retirement savings is going to increase the burden on Connecticut taxpayers by $6.5 billion between 2021 and 2040. So, faced with that retirement gap and as a way to deal with that number and bring that, give people the opportunity to encourage to save for retirement in greater numbers so that taxpayer burden goes down and that people can maintain their quality of life in retirement. The state passed a law requiring that employers with 5 or more employees not currently offering a retirement plan have to provide a retirement option to their employees, either MyCT Savings, which is free to the business and it's simple to facilitate, or the company can offer a qualified private plan like a 401k or a SEP. So the details on the eligibility for the program are get very specific, so I will go through them slowly. First of all, MyCT Savings and our administrative partner, Vestwell Savings and BNY Mellon, are the contract administrators for the program. Vestwell handles the technology part of it, and Bank of New York holds the accounts as the custodian for the Roth IRAs. The businesses that are eligible will annually get a notice from us saying that they need to make a decision one way or the other, MyCT Savings or some other plan, but they need to implement a retirement plan for their company. Employers with 5 or more employees, again, as of October 1st of last year, that do not currently offer a plan are notified. They must have at least 5 employees, and 5 of their employees must make more than $5,000 a year. The employees also have to perform their work in Connecticut, so they have to have W-2 wages in Connecticut. And the business has to have been operating since January 1 of the previous year. So the responsibilities of business owners to comply with the law are as follows. So companies receiving a notice should register for their program, enroll all employees age 19 or over who have worked for the company for at least 120 days. And it's important to note that, again, there is no cost to the business to participate. If you use a payroll company, you can hand it off to the payroll company and let them do it for you. The payroll company may charge you for that, but there's no cost to participate in MyCT Savings. Once a business enrolls and uploads their payroll and provides us their employee information, MyCT Savings reaches out to the employees and they have a couple of choices. One, they can opt out if they want. It's not mandatory for employees to participate. They can opt out if they want to. Less than 20% opt out. And if they decide later and change their mind, they want to opt back in, they can. The second option is if an employee wants to customize their Roth IRA, they can log in and they can choose to set whatever percentage contribution they want, and they can also choose from a short menu of funds to invest in. So if the third option, if the employee does nothing, then a standard Roth IRA at 3% a payroll contribution will be opened for them in their name. And this is important for employers to know. Employers cannot respond for their employees. We've heard from companies who will call and say, well, my employees all told me they didn't want to do it, and can I send in the forms? No, your employees have to respond either through the email or the letter that they receive. They can call, and there is an 800 number they can call, or they can print out a form and mail it in, but we have to hear directly from the employees. So after 30 days, we've contacted all your employees. After 30 days, MyCT Savings will start providing payroll reports to the business to let you know, to let the business owner know, or the payroll person know, how much to deduct for each of the employees. Once the process is started, the only responsibility that an employer has is to continue to submit payroll contributions, the payroll contributions from your employees, and keep your payroll up to date. So as new people come, you add them. As people leave, you take them out of the program. So the business can also choose to go, if they receive a notice from us, they can also choose to take a private plan, like a 401k or SEP, and from a private company, and all they need to do is notify MyCT Savings that they have implemented another plan, and so they are exempt from our plan. If a company already offering a retirement program receives a notice from MyCT Savings, they should also go to the website, myctsavings.com, log in with the access code that's in their notice, and just click Certify Employer Exemption. It's right on the homepage, it's at the top. So if you do receive a notice, and we try to limit the notifications that go to employers that already have a retirement savings, we do screen our lists against lists of companies that submit federal 5500 forms showing that they have a retirement plan. So we try not to reach companies that already have a plan, but sometimes we do. So detailed information on all of this is available at myctsavings.com. There's information for employers and employees. There's sections of the website for each. Information is available in English and Spanish. There are videos, articles, frequently asked questions, retirement calculators, so your employees can see how much they can save over time. And then there are call centers as well for each group, with translation services available in multiple languages. And if you have any questions, I'm happy to take them now. Before, I will also provide my contact information, and if you know, and the call center numbers and the website link, so that if you do have questions in the future, you can reach out to me, or you can call any of the other resources. Looks like there's at least one question in the chat. Jennifer, can you?
Yep. It says, I have a nonprofit client with 4 employees and they would like to participate in the plan. Is that a possibility?
The state statute says not until 5 employees, but individuals and self-employed individuals are allowed to sign up on their own. So if that person wanted to just give the information to their employees and say, here, you can sign up for this as an individual, it works the same way, except that instead of using a payroll account, you have to set it up as your own bank account, is where you set up your contributions. So, and if the company grows, then they can sign up as an employer.
There's another question. Is there a match included in the plan, and does the state match?
No. Okay, there is no match. This is a Roth IRA, so the contributions come directly from the employees into their own accounts. This is post-tax money, so once the employee contributes to their fund, When they retire, it's all their money. It's not taxable. So the program that we work with is designed to be simple for the employee or employer and employee. But there is no match, there's no administrative fee. So there is nothing for the employer to do but set up payroll and process it.
They're also asking with the Roth, usually there's a minimum of 126,000 for Connecticut. Is there a salary limit?
I believe that is the salary. It's either 120, it may depend on the age, but yes, there is a salary limit. I will just tell you as a matter of course, most of the people who are contributing to our plan that cap is not a concern for them. Many of them do not even hit the sales, the annual maximum of 7,500 or 8,000. Most of the companies that are participating in the plan are between 5 and 25 employees. So we're reaching the smallest businesses. I see the question, incentive if there's no match. The incentive is to save for their own retirement. People want to be able to have a secure future. And one thing that has surprised me about this program is that people who work part-time, almost a third of our members or our savers right now work more than one job and are saving through more than one job. So people are, I think, more aware than ever that they need to be saving for retirement, and part-time employees are keenly aware of their futures and wanting to make it better. There was one quick question. What was the last one?
How much does the cost?
It does not cost anything to the employer. It is free to the employer.
Great. Thank you so much.
You are very welcome. I will drop my contact information into the chat. And if you have other questions, you can follow up with me or go to our website, myctsavings.com. Thank you.
Thank you, Lisa, for all that great information. Next, I'm going to introduce Sarah. Sarah is going to give us some updates on some Connecticut and federal laws. Sarah Healey is a partner at Carmody, Torrance, Sandak, and Hennessey in its New Haven office. She's a co-chair of the Labor and Employment Group and a member of the firm's litigation practice. She regularly represents employers in a wide variety of employment matters in court and before regulatory bodies, and advises her clients on day-to-day issues affecting the workplace, and is also a member of our HR council. So thank you, Sarah, for being here and giving us this information.
Thank you so much for that welcome, and I'm glad to be here. Can you see my screen? Can you see the PowerPoint?
Yes.
Okay, great. All right, so we have a lot to cover today. So I'm going to try to move through it in a way that provides us all with an overview of some of the updates to workplace laws. I'm going to show some slides to kind of lay out some of the background, but please feel free to jump in with questions. I know Jennifer is going to be monitoring the chat. And she'll try to interrupt me as appropriate. And I'll also try to save some time at the end for questions as well. Before we begin, I just want to make sure that everyone knows, even though I'm an attorney, everything that we're talking about today or that I'm talking about today is for information, for educational purposes. And this presentation doesn't create an attorney-client relationship. So there's that. And then for our agenda today. So we're going to talk a little bit about some of the Connecticut legislative updates. The legislative session ended in May of this year. As many of you probably know, in Connecticut, we have a full session and a short session every other year. And this past year was a short session. So overall, not many employment-related bills passed, but there was one very significant bill that did pass that affects probably most employers, and that's the expansion of the Connecticut Paid Sick Leave law. So I'm going to spend the bulk of this morning talking about that. Then we're going to turn to some lessons from the courts and some federal regulatory updates. I have a packed agenda here, and so our intent is to provide an overview of important highlights as well as practical impacts on your business. And if you do have additional questions that I'm unable to get to today, please feel free to email me and I will try to answer those questions later as well. All right, beginning with our Connecticut legislative updates. Like I said, the big bill that passed affecting employers in our Connecticut legislative session was the expansion of the Connecticut Paid Sick Leave law. And before I get into what the changes are, I thought it would be helpful to kind of level set and go over what is our current law, some of the highlights on that. So the bill was originally passed in 2011 and became effective in 2012. Connecticut was the first state at that time to pass paid sick leave law. And since then, 18 states have followed suit. It has, the current bill has, or law has limited applicability. It does not apply to all employers, but only those with 50 or more Connecticut employees. And there's a couple of exclusions. It excludes most manufacturers, certain nonprofits like the YMCA and YWCA. And most of you are probably aware if this law applies to you currently. Not all employees of covered employers are also covered, so it applies only to service workers, which are typically hourly, non-exempt, and they're engaged in one of 69 occupations that are defined by the Bureau of Statistics, Labor Statistics Standard Occupation Classification System. So it has limited applicability at this point in time. And it also has a narrow list of uses for the sick time that accrues, which we'll tease out in future slides where I'm going to do a side-by-side comparison of the current law versus how the law will be changing soon. So Connecticut's new paid sick leave law expands coverage to nearly all employers, and it extends coverage to nearly all employees. It increases the rate of accrual, the rate of at which sick time is accrued. It expands the categories of permissible uses for sick time, as well as the list of family members for whom an employee may take sick leave. It modifies the rules for the availability of the leave, and has other restrictions and notice requirements that are going to be going into effect soon. So the new law, like I said, expands the coverage of employers. So an employer means any person, firm, business, educational institution, nonprofit agency, corporation, limited liability company, or other entity, including municipalities of the state. And there's going to be a gradual expansion of who it applies to. So as I said, currently it's employers are covered if they have 50 or more employees. Beginning in January 1st of 2025, employers with 25 or more employees will be covered. And then the following year, employers with 11 or more employees will be covered. And then in 2027, we will see employers with 1 or more employees become covered. The number of employees beginning in January 1, 2025 is determined based on the employer's payroll for the week containing January 1st on an annual basis. This is different from the current law, which looks at it for October 1st on an annual basis. Okay. So for our next slide, so there, as I said in the beginning, under the current law, manufacturers and certain nationally chartered nonprofits are excluded. We do not have an exception for those types of employers anymore. So who is exempt from this law? Well, employers with fewer than the above numbers of employees that I just listed out in the prior slide. Self-employed individuals are not covered. And then this is kind of a bit of a mouthful, but employers who participate in multi-employer health plans maintained pursuant to 1 or more collective bargaining agreements between a construction-related trade person, employee organization, and employer is excluded. What that exactly means hasn't been quite teased out, but I will address it in a future slide. So that touches on who's the employer under the new law. Who are the eligible employees also has been expanded as well. So again, as I said, under current law, it applies in a more limited basis to service workers and excludes exempt, per diem, and temporary service workers. Now, the new law expands that group of folks to any individual engaged in the service to an employer in the business of the employer. So it's no longer limited to service workers. It will apply to all employees of a covered employer. So that includes exempt workers, supervisors, executives, per diems, part-time employees. And just note that this is all employees who work in Connecticut. They have to work in Connecticut for it to apply. Only the following types of employees are excluded: seasonal employees and individuals, again, who are members of that construction-related trade person employee organization that I mentioned before that are part of a multi-employer health plan. And how you determine that is you have to look at the contract, your collective bargaining agreement, and if the contract contains an obligation that the multi-employer health plan be maintained, then the employer and the employee covered by that agreement are exempt. So that's something you have to look at your collective bargaining agreement to determine. Just going back to the seasonal employee, what is a seasonal employee? That is someone who works 120 days or less in any year. And that year is set by the employer. So it's 120 days or less worked. That seasonal employee would be exempt from eligibility of the sick leave law. All right, so accrual. The current law states that eligible service workers begin to accrue their paid time upon hire, and they accrue 1 hour per 40 hours worked, and you can cap that at 40 hours of sick time per year. The new law will allow employees to accrue beginning on January 1st, 2025, unless the employee is hired after that date. If hired after January 1st, 2025, the employee's paid sick time begins to accrue on the employee's first date of employment. We also will now accelerate the rate of accrual. So employees will receive 1 hour of sick time per 30 hours worked. This is only for hours worked. You do not earn paid sick time while you're on unpaid time off or paid time off. One important thing to note is, as I said before, exempt employees will also be subject to this law. Exempt employees are presumed to work 40 hours a week, but if your normal work week is less than 40 hours, the employer can use your actual hours worked to accrue that time for the exempt employee. Just know that this means that the employee will have to track their time in some cases, which normally exempt employees, we don't often have them do that. The number of hours of sick time is also capped at 40 hours. Employers can be more generous with the time that they allow. You can allow more time if you want to, but you don't have to. Under the law, you're required the 40 hours for every 1 hour per 30 hours worked. The front loading option still remains a possibility. Just note that it must equal or exceed what would have accrued, and just beware of prorating hours and front loading it for part-time employees. That can get a little bit tricky. So you want to be careful if you're front loading and you're using it for part-time employees and prorating it. The eligibility, your ability to use your accrued sick time has also expanded. So under the current law, an employee is not eligible to use the sick time until that employee has worked 680 hours. And unless the employee worked an average of 10 or more hours per week in the most recent completed calendar quarter. The new law replaces these limits. A covered employee may use accrued paid sick time on or after 120 calendar days of employment. This 120 days is a one-time requirement. So that means once it's met for your employee, it never needs to be met again for that same employee. Even if the employer is bought out by another employer, there's a successor in interest, or that employee has a break in service. Say that employee gets terminated and is brought back, they don't have to wait the 120 calendar days to use their time. One thing I just want to kind of point out, and I'll probably point it out again in a future slide, is when we talked about seasonal employees, we talked about them working 120 days or less. That's days worked. Note the difference here for when an employee may use accrued paid sick time. It's 120 calendar days of employment, not days worked. So just note that difference because I think it can be easily missed, but it's 120 calendar days of employment when the individual can begin using their accrued time. Some questions that people have had is, at what rate can an employee use their accrued paid sick leave? Employers are required to allow employees to use that time in 1 hour increments, regardless of what the employer's timekeeping system is. Employees are not entitled to use the paid sick leave in lesser increments unless they're allowed to do so by the employer. Okay. There's been no change in the carryover rule for paid sick leave. That means that covered employees are entitled to carry over up to 40 hours of sick time from 1 year to the next, but employers can limit the use of sick time to a maximum amount of 40 hours per year. Again, there's this exception with employers who front load sick time that meets the requirement of the law. They're not required to permit carryover because they're allowing that time to be front loaded. The definition of how, for whom basically a employee can use their sick time has been expanded as well. So under the current law, an employee is allowed to take sick time for themselves, their spouse, or their child. Under the new law, it expands that definition to family members, and it's essentially using the same definitions as the Connecticut Family and Medical Leave Act. So if you're familiar with that law, you'll know that it is very expansive as to when a person can use a CT FMLA. Those same definitions will now apply to this law. So that means spouses to whom someone includes the definition of someone who's legally married, a domestic partner registered under the law of any state. A parent includes parent-in-laws. The law now includes siblings, that's new, grandparents, grandchild. The definition of a child is no longer limited to someone who's under 18 or incapable of self-care. Also note the definition at the end here. It can include anyone who is related to the employee by blood or affinity, whose close association with the employee shows to be equivalent to those family relationships above here. So that really does expand the definition of a family member and for whom someone can take their paid sick time. It also expands the reason for use. So I put in this slide, under the current law, we have essentially 5 reasons that an employee can use the paid sick time. So again, for themselves or a family member, based on the definition of the prior slide, their illness, injury, or health condition, medical diagnosis, care, treatment of a physical or mental illness, preventative care. An employee is entitled to 1 mental health wellness day, which includes a workday or shift that the employee takes off to attend to their own emotional or psychological well-being. There are also specific reasons related to the family or domestic violence or sexual assault. So essentially, if the employee or their family member is a victim of family violence or sexual assault, and time off is needed for medical care, counseling, obtaining services from a victim services or organization, relocating, or participating in a civil or criminal proceeding, they're allowed to take sick time for that purpose, unless the employee is alleged to have been the perpetrator of the domestic violence. They're not entitled to it in that case. Just one thing to note, just to add another layer to this, Connecticut also has another law that allows employees to take 12 days of leave due to family violence for very similar reasons to those that I just mentioned. That law provides employees with 12 unpaid days of leave. Those 12 unpaid days of leave are in addition, so they can't be forced to take those at the same time as the paid sick leave law. Now, our law that goes into effect beginning in January 2025 has the same 5 reasons for use that I just went over, and it adds 2 things. It adds a closure by order of public official due to a public health emergency of either an employer's place of business or a family member's school or place of care. So just think COVID kind of reminds us of the pandemic and closures due to that. That's a reason that someone could take a paid sick leave day if that were to occur. And then a decision by a health authority, an employer or employee or family member, or a healthcare provider that an employee or family member poses a risk to others due to a communicable illness, whether or not that family member or employee has contracted the illness. So the person doesn't even have to have it, they just have to have an exposure to it. That's a reason for taking a paid sick leave day under the new law. I don't know, Jennifer, if we have any questions yet. Maybe it's a good place to stop. I know I've given a lot of information.
Sure. We have one question. If you give employees generous PTO, which can be used for sick time, vacation time, etc., does the law still apply?
So as long as you are complying with the basic requirements of the law, you can always have something that's more generous. You just need to make sure that your current policy meets the basic requirements of the law, that you're allowing individuals to accrue the hour of paid sick leave per 30 hours worked, and when they can take those times. So yes, the answer is yes, but you must satisfy the basics of the requirements of the paid sick leave law.
One other question too, with the 120 days rule, if your other benefits such as PTO time and such kick in at 90 days, say, can this also kick in the PSL time at that 90-day mark as well? So if they get it a little earlier than the 120.
Yes, I believe, and let me I'll see if I can double check that while we're on this, but I believe yes, as long as the employer agrees, you can begin to use it before the 120 days as well. I believe that is correct.
There were no other questions at this time.
All right, so we'll move on. Okay, so employee notice and documentation. Under the current law, employers may require 7 days notice when sick leave is foreseeable, and employers may request reasonable documentation if the sick time is for 3 or more consecutive workday absences. Those rights are now eliminated. So employers cannot be requiring 7 days notice, and they can't be requiring an employee to provide documentation, substantiate the paid sick leave time off. Note, however, that if an employee, the Department of Labor has put out, I'll just say this now, the Department of Labor has put out some very helpful FAQs on their website. So you can always take a look at those if you have additional questions as well. But they even know in their FAQs that even though we're not required, we can't ask an employee for documentation. Interestingly, they do say an employer may take disciplinary actions against an employee who uses paid sick leave for purposes other than those described under the law. So I suppose if you were to somehow find out that an employee is misusing their paid sick leave for a reason that is not allowed under the law, you can discipline them, but you cannot require them to provide documentation to substantiate it. There is a new records retention requirement. So employers must retain sick time records for a period of 3 years. And these records must include a number of hours of paid sick time that were accrued or provided to the employee and the number of hours used by the employee during the calendar year. And the Connecticut Department of Labor may inspect those records at a mutually convenient time if they wish to do so, and they can assess penalties for the failure to keep the required record. So this is going to be an important step for employers who don't have these types of records to make sure that they start keeping them and maintaining them for 3 years. In terms of just violations, if an employee believes that the employer has violated this law, they're able to file a claim with the Department of Labor. So that may be one reason that the department may decide to come and inspect your records. But employers are prohibited also from taking retaliatory or discriminatory action against any employee who asks to use their paid sick leave or who makes a complaint to the Department of Labor that they've, for some reason, believe their employer is not following this law. So just be mindful of that as well. Some additional miscellaneous requirements. Employers may not require an employee to find coverage for their shift when they're using their sick time under the paid sick leave law. And employers must display a poster in a conspicuous place accessible to employees. That poster can be found on the Department of Labor's website. I'll shoot a copy of the website address into the chat before we're done so that everyone can access that, where the FAQs are, where the copies of the posters are and whatnot. You also must provide written notice to employees by January 1st, 2025, or at the time of hire, whichever is later for that employee regarding this law. So what should employers do now? You're absolutely going to want to review coverage under the new law. You're going to want to look at, how many employees do you employ? And is this law applicable to you? And if so, at what point in time? Is it going to be applicable this January or the following year? You're going to want to review your current paid time off policies to make sure that they are following the law. Again, as someone asked already, you can provide more generous sick time or PTO time. You just need to make sure that at a minimum, you are satisfying the requirements of this law. You're going to want to educate your managers about the law so they understand it, and obviously prepare and provide those relevant notices that I just went over. Okay, so that's quite a bit. I'm going to turn next to a few lessons from the court, try to do a quick overview of these. There was one case from our Supreme Court that addressed Title VII of the Civil Rights Act. In this case, the Supreme Court resolved a split among federal circuits on the level of harm a plaintiff must show to have suffered an adverse employment action. If any of you have had been involved in litigation or a claim at the CHRL, you've probably heard of an adverse employment action as being part of the case, and you have to demonstrate, the employee has to demonstrate that something of harm happened to them. For a long time, it was believed that this harm had to be significant, such as someone receiving a pay cut, being demoted, being fired. Obviously, those were all considered adverse employment actions. In this case, it was a police officer who had a particular shift in a particular department that she liked, and she was transferred to another department where her shift changed, and it wasn't seen as complex investigations that she was working on, but her pay and everything else remained the same. And the court found that this type of injury is enough to be an adverse employment action. So employers want to make sure they keep in mind, when you're taking action, when you're changing someone's job duties, you want to make sure that you're looking at everything to make sure that there's no reason for that to be considered a discriminatory action. Even something as a transfer without a pay cut could potentially be an adverse employment action.
Sarah, before you go on, I'm sorry, there was a couple more questions that came in about the PSL law.
Sure.
So one was just to confirm, even though employees accrue 1 hour for every 30 hours worked, the maximum is still 40 hours per year, right?
Yes.
Okay. And if the law is not yet applicable, for example, they're a single employee, do you have to provide the written notice on 1/1/25, or would it be like 1/1/27 when it becomes applicable to that person?
When it becomes applicable to your employer, your employment. Yep,
Great. Thank you.
no problem. This one is just really brief. I think lawyers probably find this more interesting than maybe everyone else does in the workplace. But I did want to highlight more recently the Supreme Court overturned the Chevron case, which was the idea that federal agencies were granted a high degree of deference to interpret and apply statutory law. The Supreme Court recently overturned that and has said that courts will no longer defer to an agency's own interpretation and instead will employ traditional tools of statutory interpretation to ensure an agency is acting within the scope of power granted to it by the Congress. The reason why I think this could have a potential significant impact on workplaces is that, as we all know, agencies like the EOC, DOL, OSHA, and NLRB are very active, and they are often issuing new regulations that apply to our workplaces. And so this decision may make it more challenging for those agencies to go ahead and do some of the expansions that they want to do in the regulatory world. And we saw that recently, could say we kind of saw it recently with one of our recent federal regulatory updates. Many of you may have heard about the FTC's non-compete final rule that essentially would have outlawed almost all non-competes, post-employment non-competes for all workers. It received a lot of publicity, but a court recently blocked the FTC from enforcing that. It was supposed to go into effect in September 4th. It no longer will be going into effect at that time. The FTC can appeal that decision, but in light of how the courts have been looking at that, and particularly in light of the Chevron, the decision overturning Chevron, it's unlikely that this particular rule will come back in the form that it is. However, while this is good news for employers, it really does highlight a growing trend of attacks on non-compete agreements. And I would expect courts and legislatures to continue attacking the enforceability of these types of agreements and limiting the scope of their use. So we should always keep an eye on where this is going. In Connecticut, we've had several bills proposed that would limit the use of non-competition agreements. Okay, the Department of Labor, as I'm sure most of you are familiar, finalized increases to the salary level for exempt employees. And as most of you know, the FLSA requires that most employees in the United States be paid at least federal minimum wage for hours worked and overtime at not less than 1.5 times the regular rate of pay for all hours worked over 40. And of course, there's exemptions from that where people meet both the minimum wage, overtime pay requirements for employees employed in a bona fide executive, administrative, and professional type duties. These are often known as the white collar exemptions, and they have to meet a certain salary basis. This new regulation does not address those duties tests, but addresses the salary that must be applied. So effective July 1st, the salary threshold has already been increased. That increase is delineated here on this slide, and it will increase again in January of 2025 to the annualized amount of just over $58,000. And again, it will increase in July 1st of 2027. And every 3 years thereafter, there will be automatic updates based on certain wage data. So we have to keep in mind these are going to be updated regularly now. This number hadn't been updated in a long time, and so it will continue to be updated. Over here is the highly compensated employee salary. just want to point that out. There's the regular salary basis, and then this number over here is the highly compensated employee salary number. So what does that mean for us now? Well, of course, you need to determine whether any exempt employees have a salary level that's lower than these new proposed levels. And you need to decide whether to increase that salary level, or perhaps consider whether you want to convert that employee to an hourly employee, and how you're going to do that. And you need to be prepared for morale issues, because a lot of individuals do not like going from the salary to the hourly rate. They don't like what that means. They have to keep track of their time and all those different things that come with it. But you can also use this as an opportunity to evaluate and address other issues that you may have with wage and hour requirements, and use it as an opportunity to fix anything that you think needs to be fixed. So I know we're tight on time, so I'm going to move on, but do you have a question, Jennifer?
Yes. So one question on this, the FLSA rule, I know that there is a court case that was pending to block the January 1 change. Is there any update on that court case at this time?
So far, the cases that have come up have been in states where it hasn't applied to Connecticut. So no updates for us. We should be complying with this law at this time. But I think there is, maybe, are you referring to the Texas case? I think that applies only in Texas. So it doesn't apply to our employers in Connecticut.
Okay. And there was one other question that came up about the PSL law. So regarding on-call per diem employees. So even though they're on-call per diem, they'll still be eligible for the PSL time as long as they work over the 120 hours per year? Or
yes.
Yes.
Yes. Yep.
Great. Thank you.
Or 120 days. Right.
20 days. Yes, I said that wrong. 20 days.
That's okay. That's all right. All right, so the Equal Employment Opportunity Commission issued its first updated enforcement guidance on workplace harassment in 25 years this past year. And it generally reflects a number of new developments concerning workplace discrimination, harassment law that have gone into effect by virtue of court cases and Supreme Court precedent. For example, extending anti-discrimination protections on the basis of sexual orientation and gender identity. Important to note, the EOC guidance, while it is guidance, it's not legally binding, but it provides a legal analysis that sometimes the courts look to, and certainly the EOC would argue is the accurate interpretation or application of the laws that it covers. It provides examples of conduct that may be severe or pervasive, and it confirms standards of liability. A lot of what it does is kind of reaffirm what we already know, is that workplace harassment can occur via technology. So we want to be mindful of acts that happen on social media and that are brought into the workplace, or the fact that we might be working in a virtual world now where we're having meetings virtually. Conduct that occurs in those virtual rooms can be workplace harassment and constitute violations of the workplace. It addresses that. And it also addresses very specific examples of what constitutes sex-based harassment, age-based harassment, disability-based harassment, and they're all set forth here on this slide. And after this is over, I will send to Tamika a copy of our slides in a handout version so that everyone can have copies of these. I don't want to go through each one of them, but they'll be set forth here. I did want to point out that the guidance talks about associational harassment and perception-based harassment and interclass harassment, which I found somewhat interesting. Just to remind employers that harassment can occur if you believe someone associates with someone of a particular protected class. And it even now this was the first time I saw something talk about perception-based harassment, where an employer might perceive that someone has a particular protected characteristic that's inaccurate. So perhaps you think someone has a certain religious belief and you discriminate against them or harass them on the basis of that, but they don't actually have that religious belief. That's still protected according to the EEOC under these laws. And intra-class harassment occurs where the complainant's protected characteristic is covered, even if the harasser is a member of the same protected class. So, for example, a woman who like harasses another woman because of her, her decisions for child care or whatever, that could be seen as sex-based harassment, even though they're of the same gender. And the reason why I point that out is under current interpretation in the courts, there's generally been an inference that if you're of the same protected class, it's less likely that harassment has occurred. So this would be a change in that inference that exists. Lastly, the Pregnant Workers Fairness Act went into effect on June 27th. It applies to 15 or more employees. It went into effect last year. And the reason why we're talking about it this year is there were some final rules that were issued by the EOC on this. This law was not as revolutionary here in Connecticut since we already have broad protections for Connecticut workers, but I do want to point out a few things from the final regulation for us. The final regulation was issued on April 15th. It has an expansive definition of pregnant worker, which would include childbirth and related conditions, including pregnancy, potential pregnancy, lactation, use of contraception, miscarriages, all sorts of conditions that are related to pregnancy, stillbirth, or abortions, so that you become a protected person under this law with those conditions. The physical or mental condition that needs to be accommodated does not have to be severe. This is different than the ADA's definition of a disability. It can be a modest, minor, or episodic type of condition. And the regulations say that 4 types of accommodations are deemed reasonable. They're identified here. You can carry water, additional restroom breaks, allowing an employee to sit or stand, or take additional breaks, eat or drink. When they say they're deemed reasonable, the employer should be giving these unless you can demonstrate some sort of undue hardship. These are going to be deemed reasonable accommodations. And the regulation also provides a non-existent list of other potentially reasonable accommodations, such as schedule changes, reduction in hour, remote work, and the like. Employers might need to temporarily eliminate an essential function of the job for up to 40 weeks. That's unlike if someone has a disability under the ADA or regular Connecticut law. You typically do not have to eliminate someone's essential function in order to provide an accommodation, but when someone falls under this law, you may have to. Unreasonable delays in your process may violate the law. So if you're taking a long time as an employer to address the person's request for an accommodation, not getting back to them, that could be considered a violation. And employers may request supporting medical documentation for an accommodation to a pregnant worker, but only if it's reasonable under the circumstances. So you can't be demanding that an employee prove they're pregnant with a pregnancy test or provide a doctor's note that they're pregnant. Something to that effect would be considered unreasonable and a violation of the law.
Wow.
All right.
A lot of great content. Yes, amazing information. And there have been, you pointed out a few significant changes from the last time, so that's great to know. But we are now at 1 o'clock. I know a lot to share. And Sarah, yes, you said you'll share the presentation with me and I'll be able to share it with all of our registrants. So thank you so much. Jennifer, thank you for your time and your both of your time on the council specifically. And again, I think you've put information for yourself and for Glenn, so people want to join the Human Resource Council, they can. And again, this is being recorded, and this will be placed on the Chamber's YouTube channel. So just wanted to thank everyone for tuning in. Hope you had a good lunch as you were listening into this very important presentation, and we will see you all at the next Chamber event. Take care.
Thank you.
Thank you so much.
Thanks. Bye-bye.
Bye-bye.